Hi there. Welcome to the Kessler Law Firm podcast. I'm Michael Kessler. I've been a criminal lawyer here on the Treasure Coast of Florida since 1985. Today, we're going to talk about terminology. There are terms of art, industry terms in any line of work, words that sound like plain English, but may have a precise or peculiar meaning within a particular industry. Criminal law is no different. Let's talk about the terms reasonable suspicion, probable cause, and beyond a reasonable doubt, and how they fit together. Reasonable suspicion, actually reasonable articulable suspicion, is the amount of evidence the police need in order to detain a person for a criminal investigation. Probable cause is the amount of evidence the police need in order to make an arrest. Beyond a reasonable doubt is the amount of evidence a prosecutor has to present in court in order for a judge or jury to convict the accused. Let's put that into context. In a typical DUI case, the police are following a driver and they see the driver commit a traffic infraction. The police have to have probable cause to believe that driver has violated the law in order to stop him for that infraction. On the other hand, if the police see unusual driving that suggests to them that the driver might be ill or impaired, then even without an infraction, the police can stop that driver. Here's how the term is defined. The police officer has to have reasonable, articulable suspicion. That means the officer has to suspect an ill or impaired driver. The officer has to suspect that the driver is ill or impaired because of things the officer observed that he or she can put into words. He or she can articulate them, so they are articulable. That's what that word means. So the officer has to make observations that make him or her suspicious of criminal activity, that the observations are things that the officer can put into words, and they have to be reasonable. They have to be the kind of observations that would make a reasonable person suspect that the driver was impaired or ill. That would be enough to justify a traffic stop, even in the absence of a violation of a traffic infraction. We deal with these very often in pretrial motions when we're challenging the amount of evidence that the police had at a given point. We can challenge the traffic stop and try to show the judge pre-trial that the officer did not have probable cause to believe there was a traffic infraction and did not even have reasonable, articulable suspicion of an impaired driver. Some courts use those two terms interchangeably, but they're not interchangeable. They're not synonymous. They do not mean the same thing. Reasonable, articulable suspicion is less than probable cause. Probable cause is the amount of evidence the police need in order to make an arrest, whether it's for DUI or anything else. Probable cause is reasonable and trustworthy information that indicates that a crime was committed, a specific crime, and that a specific person committed it. That's all the police need in order to make an arrest for DUI or anything else. But that's not enough to convict a person at trial. In order to get a conviction, the prosecutor has to present evidence lawfully obtained that is enough, strong enough, and convincing enough to persuade a judge or a unanimous group of jurors beyond all reasonable doubt. I hope this explanation of terms has been helpful to you. If you find that you need a criminal defense attorney, feel free to reach out to me. I'm readily available. And if you've liked our podcast, well, I appreciate you joining us. And whether you're watching this on YouTube or listening to it on your favorite podcasting site, please click subscribe or follow. So next time you come back, our latest podcast will be up and ready and available for you. If you'd like to connect and find out more about us, please visit our website at www.kesslerlawfirm.com. Thank you and have a great day.